Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us Christine Hintze. Did I pronounce that right, Christine?
Hintze.
Hintze. Okay. I should have asked you before we started. Well, welcome to the show.
Thank you. Thank you.
So, Christine has secured over $10 million for women at Wall Street banks and hedge funds who were assaulted or harassed by the very executives who controlled their careers. Christine, walk me through the moment a client first called you, what she said, and what you realized about the situation she was in.
Yeah, well, thank you for having me today, Zane. I'm so happy to be here. And to discuss this extremely, pressing and relevant topic. I have seen this happen, this exact scenario happen numerous times where, I have received calls from women who are sexually assaulted or sexually harassed at work. And, whenever I receive these calls, it's everyone is most of the clients are extremely scared, nervous to reach out to an attorney. They feel as if their job is in jeopardy. And, so many of my clients have worked so hard to get to where they are in their careers. And, just some egregious action has happened that, where the client feels that they have no other option but to call an attorney. So, I really have seen this many times now, and it takes so much courage to reach out to an attorney and to take that step, especially because society tells you not to. The companies are inherently, I think, telling you not to reach out to an attorney and to keep these matters silent. So I always really commend clients who do take that step, and I find that as soon as we're able to step in, we take such a weight off the shoulders of whoever is going through this situation.
So often, I think it's probably typically women, though, although it could be men. Um, so often these people, it's by people that are in a positions of authority over them. Is that correct?
Absolutely. I mean, and I have dealt with the majority female clients, but I also have had male clients who have been subject to sexual harassment. So we've certainly dealt with that, and I know there is a big case right now that's really been hitting the headlines. It's a JP Morgan case. It's a male um, a male employee, and he was sexually harassed and assaulted by a female executive at JP Morgan, his direct boss. But we consistently see men in positions of power or females in positions of power, um, sexually harassing employees and subordinates, and it can be subtle. It can start out really subtly, even with grooming. I mean, we've seen a male executive send our client stuff about, Kiehl's products because he thought her skin should look better. And then it turned into, and it was really a slow progression into this is how you should be looking. And then next thing she knew, he was trying to like buy her a pied-à-terre in the city. Um, so, we've seen this a lot, and a lot of times when a lot of the clients, when you're in the situation, it's hard to point out these grooming behaviors, and it's hard to recognize them because they become so normalized in a way. And a lot of times when we get involved, we really start reviewing emails and text messages and evidence that we it's surprising every time a client comes to us. They say, "Oh, I have nothing. Everything's on my work email, which I don't have access to anymore." And then we're really able to put together so much evidence that clients don't think they have. We can go on Google Maps and find somebody's location if they're saying they were at a bar one night and the supervisor sexually harassed them. I mean, there's so many ways for us to find evidence. So we've really been able to do a good job with that. But a lot of times when we step in and really start reviewing everything, we will see stuff that the client might not have recognized at the time. And, once they're able to kind of step out and have that perspective on the situation, and, we can kind of get involved, it's interesting. The situation becomes a little bit different than they even thought at first.
So give me an example of a situation where the client looked at it and knew something wasn't quite right, and they came into you and they said, "I know something's not right, but I don't know. I don't think I have a case. I don't have any proof." Where you guys were able to dig something up with a little bit of creativity.
Absolutely. I mean, I think a lot of these supervisor sexual harassment situations are difficult, right? Um, you know, there's a lot of gray area in these cases, and a lot of times I've had clients who think they might have consented at one time, and then maybe, another interaction they didn't consent. And I think arguably, it is difficult for, for an employee to consent to a supervisor. I think that is difficult. If the person is directly in charge of your promotions, they could terminate you, they could give you a bad performance review. It's inherently difficult to consent to somebody with that much power at the company. So I would say a lot of times, clients will come to me really nervous because, maybe there was a time that, they got a little too drunk, and, maybe there was a kiss, maybe there was, um, somebody they had sex, and then maybe another time it wasn't consensual, but, there's so much gray area, and a lot of my clients are so nervous about these situations and really discussing them because they feel so much guilt and shame, um, and they think it's their fault. But, I think once we really, as I was saying, kind of look at the situation as a whole, and obviously we've dealt with this so much, so we really are able to um pinpoint, and especially using the legal framework that we're given. New York City laws are extremely favorable to employees. So, using the legal framework, we can really pinpoint, you know, the legality of situations, and I think that really takes a lot of shame away from our clients, once we're able to look at a case through that view. And as you asked, kind of back to the question, a lot of the evidence that we're able to find, really does support that. Like, we've had cases, a supervisor was sending the only thing that our client could find on her personal email was confirmation of subscriptions that, the supervisor was sending her bottles of wine, and this was all part of the grooming process. Like, he wanted her to um be very cultured and enjoy certain wines so she could kind of talk the talk and be the woman that he wanted her to be. And the wine subscription might not mean anything to somebody just looking at an email like that, but it really supported our whole theory of grooming. So, I think that's just one example of many.
So one thing that a lot, primarily these women are concerned about is when I have this situation and I feel like I'm threatened at work and I don't have a good resolution, but I don't have funds to hire a lawyer. So can you talk a little bit about that?
Absolutely. So our firm works on contingency fee, which means you do not have to pay any type of retainer or anything up front. We are contingency fee for a reason because a lot of the clients we are helping, just lost a job or could potentially be out of a job in the coming months. And we're fully aware of that. So, there are no retainer fees associated you know, with our assistance. It's really just, in the event of any settlement, our firm would be entitled to 40% and our clients are entitled to 60%. Now that really is the going rate in the industry. And I would say you can't put a price tag with working with the right attorney. as we've been discussing throughout this podcast, I think we have so many creative ways to increase the value of cases, to find evidence that, other attorneys might not necessarily find, and um, to develop a trusting relationship whereby our clients will provide information and, will work with us to really maximize the value of their case in a way that might not be the case with a more economical firm. So, we really devote so much time and attention to all of our cases, and, the 40-60 split, at the end of the day, I think, if clients are getting significantly more money by working with us, I really do think that the split, ends up being, something that our clients are completely happy with at the end of the day. And they've a lot of our clients have just had really good experiences working with us. So it's almost invaluable, but we do work on the contingency basis, and are really able to work with our clients to maximize the value of their case at every moment. And we do settle a lot of cases up front, but we also litigate a lot of cases. And if a case goes to litigation, our firm is, paying out of pocket for, tens of thousands of dollars, potentially in depositions, in hiring expert witnesses, and those are all expenses we front. And then, at the end of a case, that could potentially come out of a client's share, but we wouldn't do something like that unless we think we can maximize the value of the case. So, we set a lot of cases up front. We also litigate a lot. So, our firm really has that edge, especially in negotiations. I mean, I think people look us up, they see the Kanye West Jen Ann case, they see cases that we are litigating and making new case law on where, our firm is contributing to employment law and laws that are out there. So, defense attorneys will see that. And, I think that gives us a real edge.
Do you think that these hedge funds and that when they look you up and they see you're the one firm that's willing to go into court, do you think that that affects the ability to settle?
Absolutely. I think that inherently affects the value of our cases. Just our firm does have a reputation, and we work really hard every day to uphold that reputation, and you know, both with our clients and with defense firms, because the better we're able to work with our clients and develop these great relationships, I think that pays off on the other end where, defense attorneys will also see us in a light where we're extremely client driven, and we also push really hard legally speaking in court, and participating in city bar events and events that are extremely important for attorneys and also for kind of influencing and developing law.
So a woman who is has this high powered job that she's gotten, whether she's working for a Wall Street firm or a big legal firm, and then she's had this grooming sort of situation, and then she falls prey to it. Maybe an office party or something like that, and maybe even has, and it's her direct supervisor or maybe even her supervisor's boss, and she has sexual relations with this person. Maybe she was drunk, and then later she feels like this was totally wrong. I shouldn't have done that, but now I'm trapped. I consented at that particular point. Um, let's talk about that scenario because then they're thinking, I'm at fault here now. I can't do anything about this. This is not sexual harassment because I consented at this one particular moment. But later through, as I sobered up and I look at the back at this, and I think this was totally wrong. I didn't want to do this. I just the situation, and it got totally out of hand. Can you talk through the legal part of that? Because a lot of women I feel would fall into that, and then they would just say, I screwed myself. I can't help myself because I got into this situation.
Yeah, absolutely. So I see this a lot. I mean, I think there's a lot of shame that inherently comes with that, which I was, kind of discussing before. And, I think it's difficult when you're in the situation, right? You're, going to work, you're so in it. And um, legally speaking, quid pro quo sexual harassment is where you basically, you do this for me, like you have sex with me and I'll promote you. Or if you don't have sex with me, then, you're going to be taken off this project. So, I mean, we see in these situations, we usually see quid pro quo sexual harassment in one way or the other. So even if it is consensual one moment, like consensual, so, I'm using air quotes because it is arguable that any sexual relationship with a superior isn't consensual because they do have this control over your well-being, over your job. So it is a difficult line to even say that something like that could be consensual. But a lot of times, women will, say it is consensual and they engage in sexual intercourse one night. And then, um, there is so much gray area with sexual relationships where, inevitably the boss is, maybe she doesn't want to have sex again. And then there is some type of, the boss will give her the cold shoulder. And, I think human relationships are inherently fluid. And, I think we're within a relationship, there's so much that can happen. So, one night of having sex with somebody and then the next thing you're being given the cold shoulder because you did regret it and you don't want to do that again. And then all of a sudden you're taken off a project or you're put on a less favorable team, in terms of your career trajectory. And I think the you know with a lot of executives, the retaliation or quid pro quo sexual harassment is subtle, right? Like it's not going to necessarily look like a termination as soon as, you deny your supervisor sexual harassment. A lot of times it will look more like you're taken off a project, which actually could jeopardize your career future in ways that are more subtle. So, we do see that a lot. Luckily, in New York City, I mentioned before. I mean, the New York City laws are some of the most favorable laws in the country for employees. So, there's strict liability where companies are liable for a supervisor's sexual harassment. Period. In a lot of other situations, like even in New York State more broadly, if you're not in the city, it's a little bit more difficult to show um, that the company is liable for, sexual harassment. It can be done, but it's just, in New York City, there's no more questions asked. If a supervisor did it, the company is liable. So, it's really great working in New York City where we do have these favorable laws and are really able to help our clients get out of these horrible situations.
So here's an interesting take on this. So you have a client who's maybe fallen in to a situation where she had a relationship with someone and then it fell out, and now it's threatening her career. And although there is this remedy, of bringing a sexual harassment lawsuit, there's this the person who was victimized really, in many ways, doesn't as much care about the lump sum as they do about their career because they're looking, okay, I can get this lump sum, and that's all well and good, but actually, I really spent a long time in my career getting to where I am, and I've got 20 or 30 years left to go, and I don't care about the lump sum as much as I care about my career. How do you protect somebody like that, where they, maybe they have to leave that employer and go somewhere else, but how are they protected in their career trajectory because they have this stain potentially? Somebody calls up their old employer and says, well, yeah, Susie was, da, da, da. How can you help someone actually protect their career and their trajectory that they're on?
Yeah, absolutely. I mean, we always say our number one job is to protect our clients, more than, you know, recovering a lump sum or anything else. I mean, it is our job to work with our clients. We always give, and I say this again and again, we give option A, option B, option C, option A and a half. I mean, we will counsel clients as to what is legally speaking, the best course of action. But obviously, jobs are so personal. This is somebody's well-being. This is, a job is how somebody feeds their family. It is so deeply personal. And a lot of times, as you're saying, women have worked their entire lives to get to the point that they are in their career. And it is our job to work with our clients. And, I enjoy that the most. I mean, it can be challenging, but I really enjoy that challenge to figure out a way forward that is best for the client while also, um, you know, being the most successful legally speaking. So, we really work with our clients and we work with them in terms of what they want to get out of the case. And that includes protecting them from reputational harm or from, further retaliation or things that could hurt their career. So, if a client were to come to us while they are still working at a company, we typically are able to, in getting them some type of monetary recovery. There are instances where we are able to successfully negotiate, a positive reference. I mean, that's more rare, but we have done it. But normally we are always able to negotiate a neutral reference, non-disparagement clauses. So, the harasser cannot say anything bad about the person ever again. And, that is one of the most powerful tools. So, if you didn't address the sexual harassment at all, it is likely that person could continue to talk about you, talk about the fact that, you didn't acquiesce or you acquiesced and then something happened. The person could continue talking about you in perpetuity. But with us, once we get involved in our settlement agreements, those are material terms that, we don't walk away from the table unless there are non-disparagement neutral references, provisions in the agreement that will protect our clients moving forward.
So they can actually protect themselves often more by taking some sort of action, even if they're not going to court, than in some cases than if they just walked away from the job.
100%, 100%. And, these clauses are some of the most important terms. They allow our clients to get a new job and, you know, live free of, the idea that somebody could come back to haunt them later in their career. A lot of industries are smaller than you think, especially when you get to the top of an industry. Everybody. And with these clauses, non-disparagement, neutral reference, positive reference, you can, live with the idea that nobody is ever going to come back to, kind of get you later on. Like, you have those provisions in place where somebody is not gonna make comments about you.
So if I report internally and HR says they'll investigate, have I made a mistake?
So you haven't made a mistake. People come to us at all different stages of a case. So, we've gotten involved before a complaint to HR, after a complaint to HR, once somebody's complained and been terminated. We get involved at all different stages. I would say best practice is, as soon as you start to feel like something's off or, you are starting not to feel comfortable or you think something might be going on, it's best to call an attorney at that point because we can, get involved. We can help you complain. We can, as I'm saying, really counsel you on what is best legally speaking. And then, the client can make their own decision as to what they want to do. Um, and I mean, we'll make that decision together. So I think it is best practice to, for us to get involved as soon as somebody knows something is wrong. But we really work with our clients at every stage of the process. And, we can always figure something out. I mean, we're so creative with even if, somebody's resigned, we can kind of maybe get witness statements that would help, or, there's so many things to do. So I think as soon as somebody realizes that they need to call an attorney, think that's when they need to do it.
So I still have to go to work every day and sit across from this person. What are my options in that kind of scenario?
So it depends, I guess, the how egregious the behavior is, but if if somebody has been sexually assaulted by a supervisor and they have to sit next to them, we can pretty much get involved immediately and try to, help the client resign. I mean, we've had that. I had a case, a young woman who was sexually harassed by her supervisor, teetering on assault. I mean, the supervisor told her he loved her and really just uncomfortable. Such a I think this is the one I was talking about before. He wanted to, buy himself a pied-à-terre, which was an apartment for her. And in that case, I mean, we stepped in, we, got all the information from the client, and then we stepped in immediately, gave her resignation and pretty much just started negotiating immediately.
So if I really, I live month to month, like many
Yeah.
people, many places in the country, and
Mhm.
and that's especially difficult if you're working and living in Manhattan, or if even if you're just working in Manhattan and you're going to one of the burbs around there.
Yeah.
um, the cost of living is so high, and even if you're making a lot of money, it's if you lose your income, you have a short leash depending on how long you've been. And so it's like, I need this income. So
Yeah.
how do you advise somebody like that? So I'm sure that you have that happen.
We definitely do. It is so difficult, and I it's hard even thinking about, having to make that decision, especially for, a woman who's really worked her whole career to get to where she is, and y- maybe the person's like a sole provider for the kids, or it is so difficult to have to make a decision like that, to like leave your job to avoid harassment or stay, in order to make money. And we do work with clients in this situation a lot. It's ultimately the client's decision what they want to do. um we can advise as to how long we think, a settlement could potentially take, or, maybe advise as to certain like financial resources, like if there's loans that could be taken out. And we can advise if we can never guarantee a result, but, we can advise as to, where we think the case might land. So the client themselves can weigh whether it makes sense for them to pursue a loan, or to ask for, a loan from a family member or something like that, to kind of keep themselves afloat before we are able to, get some type of monetary recovery from them. Because there are instances, if a case is, that somebody might settle a case for a few $1 million, it might be worth it for somebody in that case to take out a loan and, just kind of work with us. And, we're going to try on our end to settle the case as quickly as possible, but we're also trying to settle the case for as much as possible. So sometimes it does take a little bit longer than anticipated, but, we'll always work with a person to kind of figure out, in the end, it's our client's decision what they want to do, but we'll always, work together to try to give you the most peace of mind, give you the most data points as possible so you can weigh the decision yourself as best you can.
So if you were advising me, and okay, so I had a situation where in my mind it was a clear sexual harassment, and I'm thinking I really need to quit this job.
Mhm.
Would you? I mean, this is I'm asking you just in a general sense because every case is completely different.
Yeah.
Would you generally advise the client to stick around at least for a couple weeks to try to gather evidence while you're still working, or would you tell them no? In other words, am I better off to stay and gather some evidence than to just quit on that day?
Yeah, I'm gonna give you another, another annoying legal term, but, it
No,
depends.
it depends. It depends.
Um,
That's the best legal term of all. It depends. But go ahead.
exactly,
Sorry.
exactly. So, it depends on a few factors, I would say. I mean, in most cases, not most cases, but, in a lot of cases, clients will come to us and, if they are in really bad shape emotionally speaking, like, I've had clients come to me who are really not even able to carry out like basic hygienic tasks because of the emotional distress from like a sexual assault or sexual harassment. They are really just trying to get by, like really not feeling well. If somebody comes to me in that type of situation, I would probably advise that the best thing to do is to leave. We would never want to put our clients' mental health above, more evidence or this or that. I mean, if there's like an easy grab, like maybe something we could get easily from, like a recording or a one more text message, maybe we would discuss that. But our client's mental health comes first, and if they're not feeling well, then they need to leave. But if somebody's doing okay, they think that they're up to the task of recording a phone conversation or um, you know, emailing the supervisor to get confirmation that something happened, then that's potentially something we would help the client navigate, and that could add value to their case. So it depends, how the client is feeling, what the situation is like, what other evidence exists. But that's something we would definitely work with somebody to discuss.
Walk me through what the first few weeks look like after someone comes to you.
Yeah. So I mean, I think a lot of times, as I was saying, people come to me when they are either, one foot out the door or they've just left their job, terminated or resigned. And the first few weeks will be a lot of information gathering. So this is typically the most kind of, and we're trying not to re-traumatize some people. So we really do work with our clients to work within their comfort level. Like, do they need to call their therapist after they speak to us? Do they need to space out calls, talk certain times of day, communicate via email, or, we really try to work with our clients because, um, a lot of our cases, our clients are so traumatized and it's so difficult. So, our goal is to not fully re-traumatize the client, but at the same time, the first few weeks we do need information. We need a timeline as to what's happened, all the names of people who might be involved, discussions of, getting text messages or emails or recordings. So, that it's really an information gathering phase, and it typically is the most difficult part of the case for our clients because a lot of times they have to relive in one way or another, like what happened to them. But after this phase in the case, we always tell our clients, we're able to, once we have all the information, we can take over. Like, they don't have to relive it anymore. They don't have to talk to people at the company anymore. Like, we can fully step in once we're armed with all of the information and really take things from there. So I think it does take a weight off after, that part of the case is over. But um, it can be a difficult, time in the case for a lot of clients.
Tell me about the $3 million case involving a hedge fund associate who was sexually assaulted by a supervising partner. What did that situation look like when she first called you?
Yeah, so, that particular client was still working at the company. She was on FMLA leave. The client was actually in outpatient treatment facility. So, this particular client was sexually assaulted. It happened in October. Um, and, I'm not going to say the year, but it happened in basically October in a calendar year. And then she called us in, I think, like June. So it had been a while after the sexual assault. She continued working at the company under her direct supervisor who sexually assaulted her. for, during that whole duration. And then she went on leave in May. Um, and this particular client, came from her family did not have a lot of money growing up. She really worked her way up to working at this extremely prestigious hedge fund. And she actually sent money home to her parents, helped her parents get out of, their foreclosed home. She provided for, she had two sisters. She would help provide for them as well. So, the sexual assault happened. And then it was really hard for her to get out of the situation. It's kind of like what we were discussing before. She felt a lot of pressure to make the job work, to try to continue excelling in her career, because she was such a provider in her family. But I think she stayed, and then she really, grew increasingly anxious, depressed. It was really difficult for her. She felt stuck. And she was reporting to this guy who had, you know, done such a horrible thing to her. So she ended up, she was suicidal. She ended up checking into an outpatient facility, and then we actually stepped in while she was at the outpatient facility on FMLA leave, and the company paid her, actually continued to pay her, and she was on administrative leave after we stepped in. And they paid her for about 6 months until the case was able to resolve. So, that's an example where we really were able to negotiate a situation where she was continuing to get paid. And, this was particularly egregious. So, we were able to negotiate this outcome for her where, there was no time when she wasn't being paid. And, then we were able to negotiate the $3 million uh, settlement on top of that.
So I mean, you're supposed to be a dispassionate observer. Is it hard to do that? I would think you'd get emotionally charged by some of these situations.
Yeah. So, I mean, I think one of the strengths in my practice really is the great relationships I've been able to develop with my clients. It's so important to have this trusting relationship. And, especially as a young female, I have, experienced, sexual harassment and what the world has to offer, in terms of just, navigating difficult employment situations and, just being a woman in this world. So, I really have developed such trusting relationships with my clients, and it's such a privilege to represent the women that I've represented, and, the men. And I really cherish those relationships. And I think it's important to fully understand where somebody is coming from and where my clients are coming from in order to advocate the best I can. So, I can get emotional at some points, but I think I have a lot of tools on my side to kind of then take a step back, digest the information, and just be the best advocate I can.
So tell me about um, working there at Phillips and Associates. What the atmosphere is like there? What is yeah, just what the atmosphere is like there at the firm.
Yeah. So, it's a great firm. I worked on, defense side before, right out of law school. And I actually was a paralegal for one of the managing partners before law school. So, I did defense side for a while. And, I mean, Brian Arce is Bill's managing partner. And, he is one of the best bosses I've ever worked for. Just so understanding. And, Phillips and Associates is just fabulous. We have a lot of, um, kind of camaraderie and teamwork here. I have, with each case, we have an associate on the case, a paralegal, a litigator, and then like a kind of a senior associate, and then a partner. So, each case is staffed with a whole team of people who, are always pretty available. I have plenty of calls with clients, texting relationships with clients, available on weekends. And, because a lot of these situations are dynamic, like things are happening all the time. So, I have really good, communication relationships with clients. And, it is helpful that there are so many people staffed to a case because, so many people get to know the client and are available to speak anytime something is needed. So I think that is really a great part of Phillips and Associates. And I mean, it's a great firm, and I have a lot of friends at the firm, and we constantly are kind of bouncing ideas off each other as to how to deal with a case, if there's any new like case law, or just always really trying to help each other move the cases forward and get the best results for our clients.
So I want to make sure that I've got this right. You're now part of the litigation against Kanye West involving allegations from a music video set. What does that case reveal about how abuse of power works in entertainment and high-profile environments?
Yeah. So this case, I am a part of the Kanye West case. This case is was filed more recently under a New York City law called the Gender Motivated Violence Act, which allows survivors of, you know, any kind of sexual violence, or something that would amount to a misdemeanor or felony under the law, to file a case within 7 years. So the typical statute of limitations in New York City, New York State, is 3 years. But this Gender Motivated Violence Act for events that occurred in New York allows survivors, both male and female, to file cases within 7 years. So it is, it's a great statute to take advantage of. Obviously, a lot of times in sexual harassment cases, sexual assault cases, survivors need time before, getting an attorney. A lot of times there is such difficult and, tremendous emotional distress that comes with these situations where somebody might not even be capable of getting an attorney within 3 years. And I've seen that happen a lot. So, our client in the Kanye West case, Jen Ann, um, did come to us, and there was a look back period under the Gender Motivated Violence Act. So we were able to file her case, even though it happened in 2010. And the case, I mean, it happened so long ago. And I think there wasn't a lot of, news stories out there about Kanye West in 2010. I mean, he was in his glory days back then. And, I think that case really shows a normalization of people abusing, higher ups and stars and, superstars really abusing their power in front of people. I mean, the Kanye West case, Kanye strangled our client in front of LaRue is a big superstar, and it was LaRue's music video that she was filming with Kanye West. And Kanye strangled our client in front of a whole set of people from different like production organizations and just really big players in the music industry, and everyone just turned a blind eye at the time. So it's really interesting, and I think it shows just how pervasive those dynamics were. And, this was well before the Me Too movement. So, I think people were just not used to speaking up and just kind of letting um, powerful players do what they want.
Right. So in not such a public way, so you see some of that going on Wall Street in these hedge funds and other large companies there in New York City. Maybe not publicly, but people who are in positions of power exercising that in kind of egregious ways. So let me ask you about one other one. You settled a case for a C-suite executive at a hedge fund who was fired after reporting quid pro quo harassment by the CEO. What was the company's defense?
The company did not really have a defense in that case. I think the company basically said, my client, so, we stepped in. Um, before she resigned. And, the company's defense was that she just had poor performance. Our client was, a C-suite executive. She had years and years in, the given industry, and she was very prominent. And within a few months, I think she started to pick out some interesting things the CEO was doing. I mean, As soon as she was hired, I think he was telling her, her headshot looked great and like he couldn't wait to get it up on the website. And but it wasn't anything she could pick out immediately. I think it was like, okay, that's weird. And then, the comments started to, gradually become worse and worse. And until it got to the point where, he tried to kiss her. And it is difficult because as an executive, this woman is used to, going to dinner with other executives and you know, it's tough because a lot of times, like, in more of, like, if it was 2 men, you would think nothing of going to dinner with the CEO or going to in this case, they went to a gun range and, talk shop or go golf and talk shop. So, it is just, like, a difficult line because, our client was, going along with these activities, but, it's tough for a woman, especially, with a CEO who has a tendency to, um you know, create this abusive power dynamic where, she obviously would go along because that's semi-normal, but then the CEO is really taking advantage of her and um became full sexual harassment.
So, actually, the EEOC rescinded its 2024 harassment guidance earlier this year. What does that actually mean for employees with rights claims right now?
I think that's unfortunate in terms of clients potentially having greater resources, especially before retaining an attorney. I mean, public knowledge like that is invaluable in, for unrepresented parties or, parties who are trying to figure out a recourse if they don't have an attorney or if they're just trying to navigate a difficult situation. I think, public resources like EEOC guidance are invaluable for that. For somebody to see, an authority discussing something. I mean, it's really important for that information to be out there. But the law has not changed and the same laws exist. And in practice that doesn't mean a lot because we, especially in New York City, I mean, we live in a haven of you know for favorable and more favorable employment laws. But even under federal law, those laws have not changed. And I wouldn't worry, but if you are somebody who needs that type of guidance and is even looking around at those EEOC guidelines or trying to navigate a situation and looking online for resources, I would just pick up the phone and call an attorney.
So, uh, so where can people find you? What's the best way to reach out to you if they think they have a situation?
Yeah, so I'm on the Phillips and Associates website. People can feel free to email me directly, call our office. As I said, I'm pretty much available all the time and I'm happy to always talk through a situation and maybe we aren't the right firm, but we're also always able to kind of provide resources for other firms or potentially organizations that could help somebody navigate a difficult situation at work.
Okay, Christine, thanks for coming on the show.
Thank you so much.